Welcome you to attend today part 3 of CSC Exam Technique online workshop. And as we refer to the previous two lectures, we have go through the section A and section B of our syllabus, so that our first section will focus on section C and D of the syllabus, which including the topic of shareholder meeting, board meeting, as well as share and share capital. Okay, before we look at any past exam papers, let's us to review some of the major focus of the topic, which previously has been covered in the examination. Okay, first of all, looking at section C, regarding the member and shareholder meeting. Again, the topic and question regarding company meeting are quite important in the past exam papers. Not only section A, section B is another popular question, which relates to shareholders and director meetings. So that let's take a look on some of the important application for company meeting. Okay, first of all, you should know member meetings or written resolutions. This means that the business should be conducted by the board of directors. Because of the company audience requirements, the meeting have the right, okay, to pass some resolution, to approve the resolution. Okay, so that there are two major types of resolution for shareholder meeting. Okay, one is ordinary resolution and another one is special resolution. Okay, so that the relevant resolution should be passed at the member meetings. And there are formalities required for meetings, including the election of chairmen, notice requirements, the requirement to form the columns, and also the proceedings of the general meetings. Okay, so that there are many formalities beforehand when the meeting is held. Alternatively, the member can also pass the written resolutions according to the CO requirement. So that according to the past exam papers, you can see that there has been section A and section B question asking about the meeting of shareholders as well as member written resolution. Okay, so that you should know all the CO requirements for the member meetings and how the shareholders can pass the written resolution according to the CO. Okay, another common and popular topic in meeting is AGM. So that you can see almost every year, okay, ask you about AGM. Okay, so AGM are one of the important meetings for the shareholders, okay, which are mandatory required for every company. So that you should know some procedures and requirements to convene the AGM. And also, what are the exemptions available, okay, to dispense with the requirements of the AGM. Okay, so that you can see almost every year ask you about AGM. So that when you study CSC, please focus on all the compliance and corporate secretarial requirements for conducting the AGM. Okay, another two popular questions also include notice requirements. Okay, what are the notice requirements for the shareholder meeting? And also the role of the chairman at the general meeting. Okay, and also you should know the proxy and the form of voting, okay, including poll vote and voting by hands. And also regarding the formality of the general meeting, please also look at how to adjourn the meetings. Okay, so that they are the major focus for shareholder meetings. Okay, regarding another part, board of director meetings. Okay, unlike shareholder meetings, normally the conduct of board meeting is governed by the company articles of association. And for the listed company, the director meeting is governed by corporate governance code. Okay, so that there has been some question asked you about the formality and requirements for holding the board meetings. Okay, including the election of chairmen at the board meetings. And also, as a company secretary, you are responsible for organizing the board meeting, so that before, during, and after the board meetings, what are the main duties of the company secretary in order to run the director meetings? Okay, and also look at, in case of director interest has a conflict with the company interest, how to avoid the conflict of interest. Before the board meetings, how the director can declare his or her interest. Okay, so that the resolution can be passed under the consideration of the potential interest of the individual directors. The director concerned must also be sustained from voting and should not be counted at the quorum for the meeting. Okay, so that before and during the board meetings, how to avoid the conflict of interest. And finally, loan to directors. Okay, please also consider the CO requirements regarding the whole prohibition for granting a loan, guarantee, or quasi loan to the directors. Okay, so that you should have sufficient knowledge under the CO how and when the company provide loan or guarantee to the directors. Okay, apart from Section D, today workshop also focus on Section D of the syllabus, including share capital, and debt capital. Okay, so that you should have some ideas on the type of capital. For example, ordinary shares, preference share, and deferred shares. What are the major characteristics and what are the major differences between them? Okay, you should have a general ideas on the share capital of a Hong Kong company. What are the type of share capital? Okay, and also as a company secretary, you should be familiar with the preemption rights of the shareholders. Okay, so that there are some restrictions for the transfer of shares. Okay, and also look at the company articles and or shareholder agreements. In case of any preemption rights requirements, okay, before any transfer of shares, how to certify the preemptive clause, how the shares can be offered to the existing shareholders on a pro rata basis before the shares can be sold to the third parties. Okay, and also this is common that the preemption clause are covered at the shareholder agreements. Okay, you should also know allotment of shares. Okay, which are one of the important topic in share capital, including when there are some potential investors who want to make investment for the company, then how to allot the shares? What are the procedures and formality required? Okay, and also share capital is important for the company. And according to the company articles, sometimes the share capital may be unpaid. Okay, so that some share capital should be pay up capital, unpaid capital, or partly paid share capital. Then you should know all the formality requirements regarding how to make the call, okay, for the partly paid share capital. If the shareholders is unable to pay the money on the unpaid share capital, what is the procedures for the forfeiture of shares under the articles? Okay, you should know call on shares because of the unpaid share capital. What are the proper procedures and what the director can do so that the director can call the shareholders on unpaid shares. Okay, you should also have some very good ideas on share registrar, okay, which the listed company must engage the recognized share registrar to conduct share registration and and the shareholders administrative works requirements. Okay, and also apart from allotment of shares, transfer of shares is another common and hit topic in the examination. Okay, and transfer of shares is also common exercise for many Hong Kong companies, so that you should know all the formality and procedure requirements regarding transfer of shares. And as a good evidence for the holder of the shares, the shareholder should have a share certificate. What are them? And how about what are the formality and procedures with the shareholder lost the share certificate? Okay, so that the shareholder can apply to the company for the replacements, to cancel the old share certificate and issue a new share certificate. Okay, another important area that you should know is dividend and distributions. Okay, previously there has been many questions asked you about how to pay cash dividend and or scrip dividend to the shareholders. For the listed company, how to prepare a dividend timetable. And not only the dividend, distribution is another way on return to the shareholders. Okay, so that you should know some ideas on dividend and distributions and how to prepare the timetable for the listed company. And also for the share capital part, you should also know different kind of capital of the company, okay, including warrant. Okay, that is the way to exercise the warrant into the shares. In particular, this may be common for the listed company to issue the warrant, okay, to entitle the the warrant holder to subscribe for shares at a given price. And there are also deadline and duration for the warrant. And then right issue is the common exercise for the listed company to raise up the share capital. Then you should know all the formality and procedural requirements under the listing rule. And there has been some question asked you about the reorganization of share capital, say the share consolidation and share subdivision. Okay, again, you should know everything on that. Okay, and also you should know share scheme for the listed company, which includes share option scheme and share award scheme, so that you should know and have a good ideas on the listing rule requirements on share scheme. Okay, so that you can see there are some questions asked about the share scheme. Okay, now let's have a quick look on some of the ideas which you must know for that two sections. Okay, one is general meetings. Okay, because the day-to-day operation is run by the directors, so that as a shareholders, how to convene the general meeting? Okay, there are 5 parties who can make convention of the general meeting. Okay, one is of course directors. Okay, just because on their director own motion, or because of the requested by the resigning auditor or resigning members. Okay, or member represent at least 5% of the voting of the total voting rights, and any of them represent more than 1/2 of the total voting right of all of them. The member themselves can convene the general meeting. If the quorum cannot be formed for the general meeting, then any directors or 2 or more members, so long as representing at least 10%, can call the meetings. Of course, by court orders, the court may order a meeting to be called according to the court orders. During winding up, the liquidators or official receiver may summon a general meetings of the creditor or contributory, that is the member of the company, because of the winding up procedures, because of the request by the contributories or by creditors. Okay, you should know some ideas on written resolution according to the CEO. Instead of holding a meeting, the shareholder can also pass the written resolution according to the CEO and the articles. Okay, so that the company must circulate a written resolution to all the members. Okay, so long as there are the requests by members representing not less than 5% of the total voting rights. Then the member may request the companies to circulate a statement of not more than 1,000 words on the resolution to the members who are entitled to receive the notice of the meetings. However, the company is not bound to do so, if the court is satisfied that the right is being abused or being used to secure net passivity for defamatory matters. And also, the circulation of the written resolution may be affected by sending the hard copy form or electronic form, or make available on the company website. The member may also signify their agreement to the proposed written resolution, and then send it back to the company either in hard copy form or in electronic form. After receive the written resolution, the period for the member to agree to the proposed written resolution is 28 days, or any other periods as specified in the articles. If the resolution is passed as a written resolution, the company must send a notice of that fact to every member and the auditor of the company within 15 days. The company article may also set out alternative procedures for passing a resolution without a meeting, provided that the resolution has been agreed to by all the members. Okay, so that you should know meeting as well as written resolution. Okay, as I mentioned before, AGM is one of the popular and hit topic in Section B long question. Okay, so that let's go through some major ideas and compound requirements for AGM under the CO. Okay, the CO required that every company in respect of each financial years hold this AGM. Okay, in case of private company, okay, which is not a subsidiary of the public company or a guaranteed company, then 9 months after the end of this accounting reference period. Okay, then in case of any other company, that is 6 months, okay, after the end of this accounting reference period. Okay, so that's the reason why public company or a subsidiary of a public company, though company has a very tight AGM deadline, let's say for the financial year December 31, this means that the AGM deadline should be on June 30 on the following years. That is within 6 months after the end of this accounting reference period, that is December 31. Okay, so that with the company cannot convene and hold the AGM, the court, okay, by the application of the member, can call or direct the calling of the AGM of the company. Okay, since there are many requirements for holding the GM, the CO also allows some AGM exemption, and there are 4 situations which the company can enjoy exemption from holding the AGM. Okay, one is that the company is not required to hold the AGM with everything that is required to be done can be done by a written resolution. And a copy of the document required to be laid and produced at the meeting are provided to each members on or before the circulation day of the written resolution. Another way is that the single member company is not required to hold the AGM just because there is only one members. Okay, so that every time the single member company can pass the written resolution for the AGM. Okay, or the company can dispense with the holding of a AGM by a written resolution. Okay, or exemption because of dormant company, just because dormant company is exempted from holding the AGM, any return filing, appointment of auditors, as well as preparation of the audit financial statement. Okay, so that you have a very good ideas on all the 4 AGM exemption. Okay, as a company secretary, you should know the formality requirements before, during, and after the AGM, in particular for the listed company, which is one of the great events for the listed company so that the shareholders can attend a meeting and meet with the board of directors. Okay, so that as a company secretary, what you need to do before the AGM, okay, in the listed company. Okay, just because when compared with the private company, listed company is much more complicated. First of all, check with the constitutional documents and also the listing rule and the other applicable law regarding the AGM. Okay, and then upload the annual report, notice of AGM, AGM general mandate circular at the website of the stock exchange and the listed company. Then the company secretary should draft the chairman's script, draft the voting paper and attendance sheet, and prepare the appropriate wording for procedural resolution for use by the chairman in the event of dispersion or adjournment. Okay, and after dispatch of the proxy form, 48 hours before the meetings, the company should receive all the proxy form. Okay, so that even though the member cannot attend the AGM, the proxy can ask for and on behalf of their members to attend and vote at the AGM. And also prepare a 1/4 of the arrangement with the chairman. Pending meetings should also be held with other members of the staff who can provide support at the meeting or even engage any external party, for example, signatures or some PR firm may be employed. Then the company secretary should coordinate a list of the likely question and answer for the director and to consider at the Q&A section. Okay, and also prepare a draft poll result announcement in advance. Then during the meeting, Okay, please make sure that according to the articles, ensure the quorum is present, and prepare to read the notice of AGM if this is not taken at random. All directors should attend and sit on the platform or in the front row. Apart from shareholders, other professional parties like auditor, managers, share registrar, press with allowed. External auditors, company lawyers can also attend the AGM. The auditor should attend the AGM and read out the audit opinion paragraph. Then the chairman should allow the time for the member to ask the question during the meetings, even there is a specific Q&A section prior to the formal resolution has been put to the meeting. Then the chairman should explain the method for voting of resolution, which should be taken on a poll by listed company. There are sufficient supply of ballot papers for poll voting. Poll can be demanded at a meeting according to the articles. For the listed company, all the voting of shareholder at a general meeting must be taken by roll, except in case of resolution which relate purely to a procedural or administrative matter to be rolled on by a show of hands. Then after complete the AGM, then the company secretary should collect all the book and papers, and then arrange for the copy of the approved resolution to be filed with the CR and the stock exchange. Then the company should publish the poll result announcement and also state the director attendance at the general meeting. Then the company secretary should prepare the AGM minute in which has been approved by the chairman of the meeting. Okay, you should also know notice requirements, okay, under the CO. Okay, please bear in mind 3 major days, including at least 21-day notice for AGM, at least 14-day notice for any other general meeting, and at least 7-day notice for unlimited company. And in case of creditor want you winding up, at least 7-day notice must be given. Okay, and also please bear in mind that according to the company articles, the notice of day means clear day notice. Clear days means excluding the day of dispatch of notice, as well as the day of AGM. Okay, so that please take a look on the model articles regarding the clear day notice requirements. Okay, and also you should know the role of chairmen at the general meetings. Okay, including to determine whether the meeting is properly convened and whether the quorum is constituted, to determine the order of discussion of agenda item, to make ruling to the disciplined participant, to make ruling on the procedural matters, including meeting adjournments, control discussion over the continuous issue and declare poll result. Okay, and subject to the company articles, to exercise the casting role in case of deadlock. Okay, so that in case of equality of the voting, then the chairman will have the casting role. Okay, although the chairman cannot adjourn the meetings without the consent of the member, if there is any disorder during the meeting, then the power to adjourn the meeting usually rests with the members who must give the consent. If the meeting is adjourned for more than 14 days, then the first note of at least 7 days must be given. And if the meeting is adjourned for 30 days or more, then a first notice must be given as for an original meeting. The adjourned meeting can only deal with the business left unfinished, which was adjourned. Okay, and you should know proxy form. Okay, how to appoint a proxy, including the instrument appointing a proxy, which must be in writing. And in case of appointment is a corporation, then either under seal or under the hand of the officer or autonomous. Then there are some particular which must be included. Okay, including look at the articles. Any member is entitled to appoint any other person as his proxy and role, including the rights to bid at any meeting. The proxy can also demand the poll. Okay, so that for the listed company, proxy form must be published on the website of the stock exchange. Okay, and the proxy need not be the member of the company, but any member entitled to attend and vote at the meeting is entitled to appoint another person as a proxy to attend, to speak, and vote at the meetings. The member can also appoint separate proxy to represent respectively the number of shares held by the member that is specified in the instruments of appointment. Okay, and for the private company, the voting should be based on show of hand. However, under the CO, some people like shareholders or chairperson can demand for a poll vote. The poll vote means that is the member vote at the meetings, and the number of votes each member of the proxy can cast, which is calculated by reference to the number of shares on the record date. According to the CO, who can call and demand for the poll, that is at least 5 shareholders, okay, who have the right to vote at the meeting, or a shareholders or shareholdership representing at least 5% of the total voting right, okay, or because of the chairperson who demand for a poll. Okay, then you should have a very good ideas on demand for a poll vote. Okay, also look at board meeting apart from shareholder meeting. Okay, this means that please refer to the CG code for the listed company. Okay, including that all directors has the right to attend all board meetings. According to the articles, the quorum for the board meeting is 2. And according to the CG code, the board should meet regularly, and the board meeting should be held at least 4 times a year, as approximately quarterly interval. And the CG code requires at least 14-day notice for a regular board meetings. For other board meeting, reasonable notice should be given. Okay, and also apart from the board meetings, the board may also establish different board committees, which each board committee should adopt the terms of reference as approved by the board. According to the listing rule, there are 3 mandatory board committees, including audit committees, remuneration committee, and nomination committee. And depends on the CG structure, the listed company may also establish other board committees. For example, exec committees, risk committees, safety and health committees, CSR committees, CG committee, or even P fund committee, for example. Okay, so that the director can delegate these authorities to the board committees. Okay, and regarding convening the board meeting, okay, if the meeting are not held on a fixed pay, then the chairman usually instruct the company secretary to convene the meetings. However, any director or the company secretary may convene the director meetings. The board paper and report will be circulated with the agendas or table before the meetings. Okay, so that every director should have the right to access all the agenda and board papers. Okay, and please also consider the efficiency for holding the board meeting. Let's say using virtual meetings. How to ensure that virtual meeting is efficient? Okay, also look at the chairmen at the board meeting. Please refer to the CG code. Okay, and this is for the board member collectively to elect one of their member as a chairman of the board. For the listed company, the role of chairmen and chief exec should be separate and should not be performed by the same individuals. The chairperson should ensure that all the viewpoints are heard and discussed on any way while avoiding repetition. And the model code may give the chairman a second or cutting vote in the event of an equality of the voting. Okay, and as a company secretary, you should know how to prepare before, during, and after a meeting. Let's say how to chat with the account department and the auditors regarding the draft financial statement, which are available for the board approval. In particular, for the listed company, board meeting is related to the publication of the result announcement. Okay, so that the company should have a detailed schedule of every event and also including the timetable of AGM. Then the company should draft the result announcement, any report, notice of AGM, proxy form, explanatory statement regarding share repurchase mandate. Okay, and propose the AGM day, which must be within 6 months from the financial year end. So that's the reason why June 30 is the deadline for the listed company, which the financial year end date is December 31. And also, the company should align with the public relationship and printer to arrange the cover and layout design of the annual report, and then arrange for the suitable and convenient located venue, and then convene and hold a audit committee meeting to review the draft financial statement in consultation with the auditors. Then at the board meetings, please also consider all the comments from the AC members to approve the draft audit financial statement, to recommend a final dividend, to fix the periods of book closures of the register of member, to fix the pay day and time of the AGM, and override the convening of AGM, to note the requirements and reappointments of director by rotation, as well as auditors, to approve the preliminary announcement containing the full year result, and also to consider whether any other business needs to be transacted, which include issue general mandate and repurchase mandate. And then after the meeting, the company should publish the annual result announcement as soon as possible. Where PR work is required, please also work with the PR officer to prepare and publish the press release, and the same should also be uploaded to different financial platforms and newspapers. And then draft the minute of the board meetings. Notify the share registrar the day of the book closure of member and the dividend payment. And advise the department, branch, senior executive of any decision affecting them. One good example is the announcement on the issue of bonus warrants or bonus shares or scrip dividend scheme. Okay, finally, let's take a look how to avoid conflict of interest, including that the directors has a duty to avoid any direct or indirect conflict of interest with the company. Where the company is a private company, authorization may be given by the director resolution, but where the company is a public company, authorization may be given by resolution of the director, provided that there is specific authorities in the articles which permit director to authorize those transactions. Where the director has a conflict of interest to be considered by the board, which is the board has determined to be material, then the matter should be dealt with by a physical board meeting rather than a written resolution. Okay, and please also look at under the CEO. Okay, what are the restrictions for prohibition of loan to directors? That is under the CEO. The company cannot make a loan, a guarantee, or any securities directly or indirectly to a company of the company or body corporate controlled by the directors without the prescribed approval of these members. However, the CEO has some exemption for granting the loan, policy loan, or credit transaction to the directors, including that look at the net asset or core up capital of the company. So long as the loan to director which the value is not more than 5%, that is the exemption. Okay, so let's take a look on the net asset of the company. And also with that is no financial statement, please look at core up share capital. Or because of the payment of the expenditure on the company business. Or expenditure on defending proceeding or in connection with the investigation or regulatory action. Or expenditure in connection with investigation of regulatory bodies. Okay, and that example is home loan that is not more than 10%, and look at below PowerPoint. Leasing of goods and land also not more than 10%. Transaction enter in the ordinary course of business, or intra-group transaction, that is the loan provided to the corporate director, that is a member company of the same group. Okay, please also focus on exception for the home loan. Okay, the condition is that the loan is provided to the directors to enable him or her to purchase money or main residential premises. The total amount of the loan should not be more than 10% of the company net asset or core of share capital of the company. With that is no relevant financial statement. The granting of loan to the director is on term not more favorable than that though granted on transaction entered into by the company in this ordinary course of business. Okay, which, for example, the director pays the market interest rate on the loan. And also engage the professional valuer, and then prepare a valuation report on the residential premises. Okay, so that the report should be made and signed by the professionally qualified valuation surveyor within the preceding 3 months of the purchase. And the purchase of the residential premises is secured by the legal mortgage, so that the company has priority over class of creditors in case the director fails to repay the loan. And the prohibition on loan to director also extend to certain category of person which connected with the company directors or holding company directors, including adult children, stepchildren, administrative children, adopted children of any age, parents, cohabited, for example, of the directors or holding company directors. The provision also cover a body corporate which is controlled by the directors, which a director is entitled to exercise more than 50% of the voting powers, or the director or majority of the directors are accounted to act in according with the direction or instruction of the directors. Okay, now let's also have a quick look on section D of the syllabus, okay, including common types of shares, which include ordinary shares, preference shares, and deferred shares. Ordinary shares mean carry 1 vote per share and reflect the equal right in receiving the dividend and distributions when the company is dissolved. The preference share carry a preferential right to dividend and return of capital. The holder will receive dividend before the ordinary shareholders. Preference shareholders generally do not have the voting right as an ordinary shareholders. The shares are often non-voting and sometimes be redeemable. For the deferred shares, this has less right than ordinary shares, and dividends are only paid when all the other class of shares has been paid or the dividends are paid after a specific day or specific event. Deferred shareholder cannot vote on company matter, for example, election and dismissal of the staff. Okay, and also you should know section 170 of the CO regarding alternation of share capital, which are taken in 6 forms, which include increase the share capital by allotting and issuing new shares. Increase this share capital without allotting and issuing new shares, with the fund or other asset for the increase are provided by the members. Profit capitalization with or without allotting and issuing new shares. Allot and issue bonus shares with or without increasing this share capital. Convert all or any of these shares into a larger or smaller number of shares, for example, share consolidation and share subdivision. Cancel share that has not been taken or agreed to be taken by that members, or the share has been forfeited. Okay, you should also know what is preemption rights. Okay, in the case of transfer of shares, the existing shareholder shall have the right to acquire the shares, which are to be disposed of by another shareholder first, before such share could be sold to any other outsider. Also, shareholder agreement can include a preemptive right to the effect that the company cannot issue new shares, unless this gives existing shareholders the right to subscribe for those shares on a pro rata basis to their existing shareholdings. Okay, and another way to increase the capital and to attract the investor to make investment for the company, allotment of shares is the common exercise, which is the creation and issuing of the new shares to raise the capital. The new share can be issued to new or existing shareholders, that is on a pro rata or non-pro rata basis, so that allotment of shares can have implication for any existing shareholding share proportionate, that is share dilution. And directors should have prior approval of the member to issue new shares, unless the shares are issued to the subscriber or to the present shareholder on a pro rata basis. Okay, so that the share allotment mandate needs to be renewed and approved by the shareholders at each AGM. Okay, so that for the allotment of shares, first of all, please make sure that there is a shareholder approval, and then convene a board meeting to note the receipt of the letter of application for shares and to approve the allotment of shares, issue of share certificate, and affix the common seal to the share certificate. Within 1 month, file the Form NSC1 with the CR. Update the register of member and SC register with any. Issue new share certificate. You should also know partly pay up share capital, which is the amount of money that has received from the shareholders after the allotment of shares. The issue share can be fully paid or partly paid. However, the model article do not allow for shares to be issued unless fully paid up. The liability of the shareholder for call in respect of money remaining unpaid before the commencement of the CO, that is March 2014, is not affected by the fact that the share ceased to have a nominal value, so that the shareholder remain liable for the unpaid shares. In case of unpaid shares, the director can make call on shares, and the amount of share capital that can be called up by the company, which remain unpaid by the shareholders. The call on share is the name which the director call the member to pay any amount due on new or partly paid shares. Although CO provided the shares may be issued as new or partly paid, this makes no provision for the director to call, so that all the procedure must be set out at the company articles. Where the shares are held by joint holders, each holder is jointly and severally liable for the amount of any call. And in case of the deceased shareholders, the SK continue to be liable for outstanding call unless the share has been transferred in the personal name of the personal representative. Then the director may send to the shareholders the call notice, which require them to pay the unpaid balance of the shares before a specified date. If the member is liable to pay a call or installment of the call and fail to do so by the date specified or for this amount, then the member must pay the company interest on the call or installment from the date until the call or installment is paid. Article 75 also set out how long as part of the call or installment remain unpaid, so that the director may serve a notice which must specify a further date on or before which the payment request by the note is to be made, state how that payment is to be made, and state that if the notice is not complied with, the share in respect of which call was made will be liable for forfeitures. You should also know the role of the share registrar for the listed company, including issue new shares, processing share certificate, keeping the shareholding record, registering the chain of ownership, paying agent, distribute the interest, cash dividend, or other payment to the members, shareholder alliance and communication, arrangement of management meeting, organize and running the general meeting and AGM. You should also know some procedure for transfer of shares, in particular private company, which the company article restrict the right to transfer the shares. And the director can refuse the registration of transfer. The company must notify the transferee within 12 months from the day of the loss of transfer. The effective date of share transfer is the board approval date or stamp duty date, whichever is later. And fully paid share shall be free from any restriction of transfer and shall also be free from all lenience. For the transfer of shares, there are share transfer form and document which include insurance transfer and bought and sold lot. Insurance transfer is the form of transfer from the transferor and transferee, which also include the stamp duty of $5 The bought and sold lot is the contract notes for sales and purchase of the shares. So that the stamp duty will also based on the consideration and the net asset value of the company, whichever is the highest one. So that payment of stamp duty effective the transfer of share legally. If there is no stamp duty, the transfer of shares has no legal binding effect. Stamp duty is also payable on the bought and sold lot, which the current stamp duty rate is 0.1%. On the consideration or the NAV of the company. The stamp duty should be paid 2 days after the sales or purchase effected in Hong Kong, or 30 days after the sales or purchase with effected elsewhere. When submitting the document for stamping, the company should also submit the articles, S&P agreement with any, the statement whether the company and this subsidiary has acquired any landed properties, latest audit financial statement of company and this subsidiary, that is the consolidated accounts, certified management account of the company and these subsidiaries from the end date of the latest audit account made up to the date within 3 months, a written confirmation with no audit account, and any other documents. Okay, so that for the transfer of shares, board approval is required. After obtaining the board approval, please arrange the stamping of the interest transfer and bought and sold as the stamp office, and also issue the new share certificate and cancel the old share certificate. Update the register of member, register transfer, and certificate controller register. Interestingly, there is no CR form to be filed. Okay, so that we don't know who are the shareholder in case we only look at the annual return. Okay, so that the company can only need to provide the detail of all the shareholder as a subsequent form NAR1. Okay, so that's the reason why the person has the right to make inspection on the register of member, and the register of member can really reflect the real transfer of shares during the year, because from company search we are unable to look at the new shareholder record. Okay, you should also know share certificates, which the private company must issue the share cert within 2 months, and the listed company is required to issue share cert within 10 business days after the share transfer. The cert must be dated and be issued under the seal. Okay, and there are some content to be included. Okay, including the company share capital, different class of shares, the voting right attached to the shares in each class. The class of share composed of different pay-up status. For example, some fully paid and some partly paid. Then there must be a distinctive number for each share. If the company has a class of shares, the holder of which are not entitled to vote at general meeting, the descriptive of title of the shares that the class must include the word non-voting on any share certificate. Okay, so that the private company is required to issue share certificate within 2 months after the allotment day or transfer of shares. For listed company, the deadline is within 10 business days. Okay, after the transfer of shares. Okay, how about with the shareholder carelessly lost the share certificate, what they can do? Okay, the member which lost the share certificate must submit an application to the company for the issue of new share certificates and provide a letter of indemnities. The director then can pass the written resolution to approve the cancellation of the lost share certificate and issue of the new certificates. The register of members should also be updated. Then how about the listed company? Okay, let's take a look on the latest market value of shares, which is less than 200,000 Hong Kong dollars. Then the lost share certificate must complete and sign the Form NS1. And after receipt of Form NS1, the company should publish the Form NS3 on the company website for 1 month, with no claim or loss within 1 month after the publication of the Form NS3. Prepare a share certificate and submit the same to the director for approval. Board resolution should be passed to approve the cancellation of the lost certificate and issue new share certificates. Whether the cancellation of the original certificate and issue the new certificates. Notify member to collect the certificate. And within 14 days after the issue of new share certificate, publish NS4 on the company website for a period of at least 7 days and deliver a copy of the Form NS4 to the stock exchange. How about with the latest market value of shares are $200,000 or more? Then apart from the above mentioned procedures, okay, publish the Form NSC1 and then publish the Form NSC3 on the website for 3 months. And not only website, the Form NSC1 in the Gazette must be published within 1 month after the publication of the company website. With no claim or loss within the 3-month period, prepare a new share certificate and submit to the board for approval. board resolution should be passed to approve the cancellation of the lost share certificate and issue new share certificates. Okay, now look at distribution. Under the CO, distribution means every description or distribution of the company asset to this member, whether in cash or otherwise. However, excluding the following distribution, that is by way of fully or partly paid bonus shares, redemption or buyback of shares, or out of unrealized profit, the reduction of share capital by extinguishing or reducing any member liability on any part of the company share in respect of share capital not yet paid up, the distribution of assets to the member because of winding up, the financial assistance given by the company to a members. So that you should know some restriction under CO for distribution. One is that the company may only make a distribution out of profit available for distribution. The company profit available for distribution are these accumulated realized profits, less these accumulated realized loss. Okay, so that is the requirements for paying of dividend and distribution. Okay, according to the model articles, the company may at general meeting declare final meeting, but the final dividend must not be more than the amount recommended by the directors. The director may from time to time to pay interim dividend, so long as the director is certified by the profit of the company. Okay, and for the listed company, not only the cash dividend, the listed company may also pay scrip dividend under the scrip dividend scheme. Scrip dividend can offer shareholder the options of receiving their dividend in the form of new shares instead of cash. Okay, so that the shareholder can increase their investment without brokerage fee, stamp duty, and dealing costs. And the capitalization issue also includes scrip dividend scheme, which profit are capitalized. This comes with public announcement and circular, setting out the detail of the scrip dividend scheme together with the election form. The shareholder can opt to receive cash dividend in whole or in part in the form of new shares instead of in cash. Okay, and you should also know how to prepare the timetable for dividend by the listed company. Okay, including how to fix the record date. That is the day which the identity shareholder based on the name in the book, okay, are entitled to dividend. Book closure periods. Okay, this must specify the periods which the company register member will be closed to identify qualified shareholder for the dividend entitlement. The last day to lodge the transfer of securities, so that the company must provide the deadline for lodging the share registration to qualify for the entitlement. Okay, the deadline is usually set out at the close of business hour on the selected business day. Finally, ex-entitlement day, because under the current T+2 settlement system by CCAS, the ex-date is the trading day immediately before the last registration date. Okay, and also you should know warrant, which entitle the holder to convert the warrant into a fully paid shares as a predetermined price. The warrant holder is not a member of the company. They are not recorded in the register of member. They are not entitled to attend the AGM or voting at the AGM. The warrant must expire not less than 1 year, but not more than 5 years. Okay, and also you should know right issue for the listed company, how to raise up the capital. The right issue is the offer by way of right to existing holder of securities, which enable those holder to subscribe security in proportionate to their existing holding. Right issue need not be underwritten. Where the right are underwritten, the underwriter must be Type 1 SSO licensee or the controller of substantial shareholders. Okay, apart from that, you should know new pay right shares for right issue. This means that offer of security by way of right are required to be converted by reliable provisional letter of allotment or other negotiable instrument, which must state the time being not less than 10 business days in which the offer may be accepted. The rights offered to the existing shareholder are normally traded as a separate temporary securities from the parent shares, which is known as New Pay Y. Okay, so that the majority shareholder approval is required with the right issue or open offer could increase either the issue shares or the market capitalization by more than 50%. And the controlling shareholder are not allowed to vote. There are three options for the shareholder in right issue. One is accept in full or in part. Another one is decline the offer, allow the new pay right to left upon an expiry, or relent and trade the new pay right. Okay, you should also know some share restructuring, like share subdivision and share consolidation. The share subdivision increase the number of shares by dividing this existing share proportionally into multiple subdivided shares. This will result in the proportional reduction of the market price per subdivided shares. The share consolidation is a decrease in the number of issued shares by merging this existing share proportionally into new consolidated shares. This will result in a proportional increase of the market price per consolidated shares. However, the total value of the share capital remain unchanged for both of them. Okay, so therefore the listed company, this may affect the board lot size. Board lot size means the standard number of shares that constitute one lot of trading of shares. In determining the new board lot size for the consolidated or subdivided shares, the listed company should select a new board lot size which will minimize the creation of all lot. The new board lot should be an integral multiple of the original board lot size for an increase in board lot size, or an integral divisor for a decrease in board lot size. The new board lot must be less than 900,000 shares, and the value of the expected new board lot should be greater than 2,000 Hong Kong dollar. Okay, finally, let's take a look on share scheme under Chapter 17 of the listing rule, which governs share option scheme and share award scheme. There are three types of share scheme. Okay, one is the share scheme involving the grant by company of new shares or option over the new shares for the benefits of the participant of the scheme. The second is the share scheme that are funded by the existing share of the company. The third one is the share scheme of a principal subsidiary of the listed company. Okay, so we have a very good ideas for the major focus for Section C and Section D of the syllabus. Okay, now let's have a quick look on the relevant past exam paper, Excel report, and the marking scheme. Okay, so that let's take a look. Okay, on okay, first of all, now let's take a look on Section C, okay, of the past exam papers. Okay, before we look at the question and the scenario, okay, first of all, we would like to take a look on the question requirements. Okay, first of all, advise Jerry with the company and this subsidiary together with AKP can change their accounting reference date to December 31. And also, I highlighted how this could be accomplished. And also, another headline is influence of the annual return filing date of this company after the change of their ARD. Okay, 13 mark. Okay, so that you need to write around 2 pages. And also the issue in relation to the next AGM, but we have no story before we look at the scenario, but this carry 12 mark. Again, 2 pages for that question. Okay, now let's take a look on the background and scenario of the question so that you can link up the information with the question requirements. What is the type of the company? Okay, that is a public company led by shares. Remember, public company. And the company is the holding company of some subsidiary, which include public company and private company. All of them are Hong Kong company and none of them are listed company group. The company and some of this subsidiary has the ARD, which is March 31, while other subsidiary has the ARD on December 31. The director wondered whether this would be more efficiency or not to have a single ARD of December 31 for all the company, just because of separate legal entity and they need to consolidate the financial statement. The Jerry is also the director of AKK, that is a guarantee company. A KKP is also considered this ARD change from 31 March to 31 December. So that all of them are relevant to Part A question requirements. How about Part B, that is AGM? Their treasury group, Green, formed a company and bought some share in the company. And this can campaign on environmental issue in transport and encourage shareholders to vote against the board and disperse the meeting. Jerry asked you with the corporate representative of Green is entitled to attend the AGM and to ask questions, whether the company can refuse to answer. As most of the shareholders are resident overseas and cannot attend the AGM in person, then Jerry is worried about the resolution proposed at the AGM may not be passed with the corporate representative votes against their resolution. Okay, so that the final paragraph relates to answer B. Okay, before we look at the structured answer, first of all, look at the examiner report. The first part of the question requires advice on changing the accounting reference date, and the second part is to discuss the corporate representative and overseas shareholders at the AGM. This was the second most popular question, but unfortunately, their performance may not be so good. For the Part A, the student performance is not good because they are unable to demonstrate sufficient knowledge of the ARD or the accounting reference periods, nor they accurately explain the process for training the ARD. However, they are able to discuss the influence of the annual return filing day after the training of the ARD. For Part B, student performance is much more satisfactory. Candidates were able to expand the right of corporate representative as well as using online meeting for overseas shareholders. Okay, so let's take a quick look on the subjected answers. Okay, first of all, please define what is ARD, okay, according to the CO. The ARD is the anniversary of the company's primary accounting reference date and is the end date of subsequent accounting reference periods. And the accounting reference period is the period by reference to which the company annual financial statements are to be prepared. The accounting reference period is a period of 12 months, okay, beginning immediately after the end of the period's accounting reference period and ending on this ARD, unless the ARD period is shortened or extended by alternation of the ARD. If the company is a holding company, consolidated financial statement must be prepared. Okay, unless the company is partially owned subsidiary where no member requests the preparation of a consolidated financial statement, or where members agree in writing that consolidated financial statement will not be prepared. Which cell is a holding company, which is required to prepare the consolidated financial statement. There is more efficiency to have a single ARD of December 31 for all the company. So that, according to the CO, the ARD can be altered by resolution of the directors. The director must specify in the resolution a new ARD, that is December 31, in relation to the current and previous accounting reference periods and every subsequent accounting reference periods. Once the company has altered this ARD and prepared this financial statement up to December 31, this accounting reference period commenced from January of 1st and end of December of 31 each year. If the company is a public company or a guarantee company, then the company must within 15 days, okay, after the day of the resolution, specifying the ARD, deliver Form NAC4 to notify the CR, the new ARD. The company shall allay this AGM, the financial statement, and make up a date not more than 6 months after the end of the accounting reference period, or 9 months in case of private company not being a member of the group, which include a non-private company or a guarantee company. Okay, now let's take a look on after the change in ARD, what will be the influence on the annual return filing date? Okay, there are 3 major types of company as mentioned by question. For private company,
there is no change on the filing date of any return because the annual return of a public company must be filed within 42 days after the anniversary date of this incorporation. For public company, the annual return must be filed together with the certified true copy of the financial statement within 42 days after the company return date, that is, 6 months after the end of the company accounting reference period. For guarantee company, the annual return must be filed together with the certified true copy of the audit financial statement within 42 days after the company return date, which is 9 months after the end of the accounting reference period. Okay, so that is the second part of the question regarding annual return filing. Okay, regarding part B of the question, again, please use corporate representative as well as why to attend, vote, and speak at the meeting at headline. Okay, for the corporate representative, their rights are no different from other members. When being a corporate member, may by resolution of this director authorize corporate representative to attend the AGM. If more than one person is authorized, the authorization must specify the number and class of shares in respect of each person is so authorized. The person authorized is entitled to exercise the same power as this nominee. Okay, regarding the right to attend, vote, and speak at the meeting, all corporate members and their corporate representative are entitled to attend and vote at the AGM. Their representative may vote on a show of hand or by poll. All corporate members and their corporate representative are entitled to speak and ask questions at the AGM. Although those attending have the right to speak, they may be prevented from doing so in order to keep the meeting to a reasonable length or to maintain a good order. The chairman of the AGM should allow different opinions to be heard and should not prevent the representative from asking any question. The chairman has the right to maintain good order and may restrict the number or length of questions to keep the meeting to a reasonable length. The chairman should ensure that all questions put by those attending are answered and should ideally prepare answers to expected questions in advance of the meeting. Another headline which we should use is dispersion at the AGM. Members can be ejected from meeting if their behavior is so dispersive as to make continuing the meeting impossible. Such events are extreme and very much at last resort. Every effort should be made to allow members to speak and ask questions in an appropriate manner. How about with the shareholders who are resident overseas? They cannot go to Hong Kong to attend the AGM in meeting. Then please advise one headline to appoint a proxy. All members have the right to appoint one or more proxy to attend, speak, and vote either a show of hand or a poll. Where a member appoints more than one proxy, each proxy must be appointed to exercise the right according to the different shares. Therefore, shareholders who are resident overseas may appoint one or more proxy to attend, speak, and vote on behalf at the AGM. Another headline is voting. To obtain sufficient variable voting for the proposed resolution at the AGM, the chairman has a duty to ensure all available votes are cashed and counted. In case where a resolution are defeated on a show of hands, the chairman is aware that there are a substantial number of proxy votes in favor of the resolution. The chairman should demand a poll. On a show of hands, every member in person or a proxy has to vote by one vote only, respective of the number of shares held, that is head count. On a poll, however, the number of shares held determines the number of votes the member may cast either in person or by proxy. So that in the event of the equality of the vote, the article often gives the chairperson a casting right. Okay, the final headline is online meeting because of the advancement of the technologies. The CEO has introduced the use of technologies as a shareholder meeting. According to the CEO, a company may hold a general meeting at 2 or more places using any technology that enable the shareholder who are not together at the same page to listen, speak, and vote at the meeting. This can enable the shareholders who are not at the same page to listen, speak, and vote. If a meeting is to be held at 2 or more places, the principal place of the general meeting and any other place or place of the meeting must be specified in the notice of the general meeting. Therefore, if this is allowed by the articles, the company may hold the AGM at one or more space using any technology that enable the member who are not together at the same page to listen, speak, and vote at the meeting. If there is no just provision in this article, backstop resolution should be passed to include the same in this article before the AGM.
Okay, now let's take a look on another question on 2023 June. Okay, before we look at the scenario and story, let's take a look on the question requirements. Okay, first of all, provide opinion on the proposed timetable. Okay, that is the timetable. And advise about every aspect of this timetable so that I highlight all the key events and the key day for the timetable so that you need to provide the opinion. And this question carries 70 marks. Okay, this means that you should write around 3 pages for that 70 marks. Another question asks you about the appointment of proxy to attend, to speak and vote at the AGM, 8 marks. Okay, so that you are expected to write around 1.5 pages for 8 mark question. Okay, now let's have a quick look, okay, on the question requirements. What is the type of company? The company is a Hong Kong company, but their shares are listed on the Hong Kong Stock Exchange, so that the company is a listed company. John, the CFO, compile and propose the chairman the following timetable in relation to the publication of the annual result for the year end December 31. Okay, so please take a look on every event and also the date, which are the common example of the timetable for the listed company. Okay, and Mary is the minor shareholders who has physically attended AGM in the past. However, she will be unable to attend the AGM in person. She wonders she can appoint proxy to attend the AGM on her behalf, and whether she will be disposed of her right to attend in person, whether the duly signed proxy form has been delivered to the company. Okay, so that the final part relates to part B, 8 mark question. Okay, now let's take a look on the examiner report. The question asks about the comments on a proposed timetable and also give advice on proxy appointment at the AGM. Unfortunately, this was the worst performed answer in this section. In part A, the student could correctly comment the day of board meeting, day of dispatch of notice of AGM, and the day of AGM. However, the majority could not clearly explain how to compare with and comment on the record date and final dividend payment date. Okay, that is the after the AGM, how to pay dividend. Regarding part B, student performance is much more satisfactory. Student overall demonstrate correct and reasonable understanding of the procedures regarding appointment of proxy or proxy and the rights of the proxy at the AGM. Okay, now let's take a look on the subjective answer, how to comment the timetable. Since there are different events, you can use each of the event as the headline of your answer. Okay, first of all, day of AC meeting on March 30. What is the comment on that? Okay, first of all, there is no secretarial requirement for the day of AC meeting. The AC meeting should normally held 1 week before the board meeting so that there is sufficient time to solve any issue that has been waiting at the AC meeting before the board meeting. Therefore, March 30 is allowed for AC meeting. However, this is not a good CG practice because if any issue has arrived at the AC meeting, there will be insufficient time to revise the financial statement or any result before presenting them to the director for approval at the board meetings. How about the day of board meeting on June 31? According to the listing rule, the result announcement must be public, okay, before the earlier of the commencement of the morning trading day on the next business day after the board approval. The listed company must publish the result not later than 3 months after the end of the financial years. This means that the deadline to hold this board meeting to approve the annual result announcement is March 31. Therefore, the holding of the board meeting on March 31 can comply with the listing rule. However, touch wood, The company should aware that potential issue to avoid, for example, typhoon number 8, bad rainstorm, or adverse weather condition, which being hosted on March 31. This could prevent the board meeting to be held and to approve the annual result announcement. As a result, the company may not be public the annual result announcement on March 31. This should be suggested that the board should reschedule the meeting to the earlier date in March 2023 to allow for the possibility of the adjournment. How about the dispatch of notice of the AGM on May 2? The listed company must give this member a reasonable notice of the general meeting, which is at least 21 days for the AGM. This notice is exclusive of the day which it is searched or deemed to be searched and the day for which this is given. Any report shall be sent to every member no more than 4 months after the end of the financial year. After any report and notice of AGM are sent to member at the same time, the board should consider reschedule the dispatch date to an earlier date in April 2023. How about the book closure periods from 26 to June 30? The original member will be closed from June 30 to June 6, 26 and June 30, inclusive during which time no transfer of share will be effected. To determine the shareholder entitlement to attend and vote at the AGM, in order to qualify for attendance at the AGM, all documents in relation to the transfer shares must be lodged with the share registrar no later than June 25. As the AGM is scheduled to be held on June 30, the group hold period from June 26 to June 30 allow company share registrar sufficient time to ascertain the shareholder entitlement to attend the AGM. Okay, how about the day of AGM on June 30? Listed company in each financial year hold this AGM within 6 months after the end of this accounting reference period. The deadline to hold the AGM is June 30. Therefore, the holding on AGM on June 30 can comply with the listing rule. However, touch wood, similar to result announcement, the company should be aware of the potential issue to avoid. For example, typhoon number 8 signal, bad rainstorm warning, and adverse weather condition if they are hosted on June 30. This can prevent the company to hold this AGM. This was suggested that the company should reschedule this AGM to an earlier date in June 2023 to allow the possibility of adjournment. The adjournment AGM is normally to be held on the same day of the following week at the same time and place, or any other day and any other time paid that the director determines. How about the record date on July 7? When the listed company decide on a record date to determine the shareholder entitlement to final dividend, this must ensure that the last day for trading in the security with entitlement fall at least 1 business day after the general meeting, with the entitlement requires shareholder approval. This means that the record date must be at least 3 business days after the AGM in view of the 2T plus 2 day, that is 3 day plus 2 day settlement system. Therefore, if the AGM is held on June 30, the record date on July 7 can comply with the listing rule. How about the final dividend payment on July 21? There is no statutory requirement for the dividend payment day. The dividend payment day is determined by the directors. Therefore, the director may decide to schedule this 2022 final dividend payment day for July 21, provided that the dividend warrants are ready to be dispatched to the shareholders on or before July 21. Okay, now let's take a look on Part B regarding appointment of proxy at the AGM. The CEO provided that any member who is entitled to attend and vote at the meeting may appoint a proxy to attend, speak, and vote on his or her behalf at any general meeting. The proxy need not be a member of the company. The proxy is appointed for an individual meeting or an adjournment of that meeting. With the company as share capital, the member may appoint separate or multiple proxies to represent respectively the number of shares held by the member. That is specified in the instruments of appointment. Any member who wishes to appoint a proxy to attend and vote must arrange for the proxy form to be lodged with the company share registrar within 48 hours before the time of holding the AGM or any AGM adjournment. In calculating the 48 hours, no account is to be taken from any part of the day that is a public holiday. The listed company must send the two-way proxy form to enable them to instruct the proxy on how to vote at the meeting. The two-way proxy form enable the appointing shareholders to indicate his or her intention to vote for or against a particular proposed resolution. Where the chairman of the AGM is appointed as the proxy, and there is no direction to vote for or against any or all resolution, the chairperson will usually vote in favor of the resolution. Shareholders may limit their proxy to only part of their holding, and they can appoint more than one proxy. Each proxy appointed to cover separate part of their shareholding. Finally, the member who is entitled to attend, speak, and vote at the AGM remain entitled in respect of the AGM or any adjournment of the AGM. Even though a valid proxy form has been delivered to the company, the authority of the proxy will be revoked with the appointing shareholders attend the AGM in meeting. Okay, so that there are no advantages for both the shareholder and proxy to attend the AGM at the same time. There is no duplication for voting. Okay, now let's continue look at 2022 June. Okay, this question asks you about, including the formality in declaring the dividend and the circumstance that the shareholder approval is required to approve the declaration of the dividend. And what is the meaning of scrip dividend scheme and the advantages for issuing the scrip dividend, and why the register of member will be closed, and what regulation governing the book closure. Okay, so you can see the question carry many questions, and I highlight every important part which you must cover them at the answers. And the mark is 14 marks, so that you are expected to write around 2 from 5 pages on that. And regarding B, how can the interim dividend day and the dividend day can be determined? Are the shareholders entitled to any dividend on these 2 days? Okay, and another question asked you about draft the resolution regarding the declaration of the interim dividend and the book closures. Okay, so that the mark is 11 marks, so please write around 2 pages for their answers. Okay, now let's take a look on the scenario and information on the question. The type of company is a Hong Kong company, and these shares are listed on the stock exchange. Mary is a shareholder who acquired 2,000 shares. So you know that the company will declare dividend of $0.35 per share, and the dividend will be payable in cash with a scrip dividend alternative. That is the timetable, including book closures from August 18 to August 19. Record date is August 19. Okay, now let's take a look. The scenario is very simple, how to match with the question requirements. Okay, only a smallest number of candidates opt this answer, which focus on formality involved in the declaration of dividend of listed company and on shareholder entitlement to dividend. Performance was disappointing, because they are unable to determine the interim dividend day and dividend day. And some students did not know what is a scrip dividend. So that is very disappointed that they cannot draft resolution regarding the declaration of the interim dividend and book closures. However, some students who were familiar with the relevant topic score very high mark. Very interesting comment on that. Very extreme result. Some students has a very high mark, but some of them has a very low mark. Okay, now let's take a look because of the heading. We highlight all the heading and then please present answer according to the heading. First of all, circumstance where shareholder approval is required to approve the declaration of dividend. What is dividend? The company may only pay a dividend out of accumulated realized profit, whereas we accumulate realized loss. Realized means in the form of cash or other form readily convertible of cash. A listed company may only pay a dividend with the net asset are not less than this core of share capital. An interim dividend payment may be justified by interim result announcement. This may be paid with the approval by the board of directors. the director should make sure that the payment is certified by the company income account. All dividend payment must be demonstrated certified by the last audit account laid before the AGM. This can only be paid with the recommendation of the directors and by approval of the audit resolution of the shareholder at the AGM. How about the second headline regarding scrip dividend and disadvantages? Scrip dividend is a type of dividend. The company provides shareholders with the options to receive their dividend in the form of shares instead of cash. This means the shareholder will receive either a cash dividend or shares. Shareholder will receive a form called a notice of election whenever the scrip dividend is available for dividend being declared. Shareholder has the right to elect to select the interim dividend in cash or in the form of fully paid new share in lieu of cash or partly in cash and partly in the form of fully paid new shares. Shareholder has the right either to opt to receive new share for only the dividend being declared or for all dividend with the scrip dividend is available until they revoke the election by notice to the share registrar. The scrip alternative will enable the shareholder to increase their investment without incurring brokerage fee, stamp duty, and related dealing costs. The company will also be benefited by retaining the cash as working capital, which the shareholder elect to select new shares. Now look at the reason for book closure and the regulation governing the book closures. The purpose of the book closure is to determine shareholder entitlement to the proposed interim dividend. During the period from August 18 to August 19, no transfer of share will be registered in the transfer book or register of member. Shareholder whose name appear on the register of member on August 19, being the record date for the dividend entitlement, are entitled to the proposed interim dividend. According to the CO, the company may close this register of member for any period not more than 30 days in each year. The book close periods may be extended for a further period of not more than 30 days, not more than 60 days over the whole year by passing a member resolution. The company must publish the announcement at least 10 business days before this intent to close this register of member. When there is an alternation to the book close date, the company must notify the stock exchange and publish a further announcement at least 5 business days before the announced closure or the new closure, whichever is the earliest. Okay, so that so long as you are able to use the headline according to the question requirements and then based on your knowledge to present a systematic answer. Now look at part B. Okay, regarding the declaration of the interim dividend day and dividend day, and the shareholder entitled to dividend on these 2 days. Okay, that is the headline. First of all, when the company declares the dividend, this will set a record date and the book closure date for this register of member. The ex-dividend day is normally 2 business days before the first day of the book closure date due to the current T+2 settlement system. The shareholder whose name appear on the register of member on the record date will be entitled to the dividend. With the shareholder purchase shares on the ex-dividend day or after, he or she will not receive the said dividend payment. In that, the shareholder get the dividend. With the shareholder purchase the share on or before the interim dividend day, that is, any day before the ex-dividend day, he or she will receive the dividend. According to the timetable, the ex-dividend day is August 16. Okay, and therefore, according to the timetable, the interim dividend day is August 15. Okay, which is based on T+2 settlement system. Okay, because the book close period is between August of 18 and August of 19. Okay, so that T+2, we can determine both the ex-dividend day and dividend day. Okay, which is August 16 and August 15 respectively. Okay, now please draft the resolution regarding declaration of the interim dividend and closures of register of member. Okay, that is, this was resulted that the interim dividend for the year end, December 31, of 0.35 Hong Kong dollar per share shall be paid on September 19 to the shareholder whose name appear on the register of members on August 19, that is the record date, and that the interim dividend will be payable in cash with an option granted to the shareholder to receive new and fully paid shares in lieu of cash under the scrip dividend scheme. For book closure, this was resolved that the register of member be closed from August 18 to August 19, both days inclusive, for the purpose of determining the shareholder respective entitlement to the interim dividend.
A look on 2021 November. Okay, now let's take a look on the question requirements. I highlight the word advise Steve on his argument and expand the proper procedure for convening the board meetings. Okay, and another part is the formality for the appointment of an alternate directors. And interestingly, in the part B, your answer should be different with the company are a listed company in Hong Kong. Okay, so that 13 and 12 are respectively, so that you are expected to write 2 pages for each of A and B respectively. Okay, the only difference is that assuming the company is a listed company. Okay, now let's take a look on the scenario and information. Okay, first of all, the company is a private company and adopt the model articles. However, please note that in part B, we should assume that the company is a Hong Kong listed company. And then the chief executive convene the board meetings, okay, on November 2. Okay, so that only 1 day to call the director to attend the urgent business. The director attended the board meeting, but he argued that this was not properly convened because, first of all, inaccurate notice. Okay, the meeting was convened through a phone call, not a written notice. The company has a schedule of day of board meeting, but November 2 was not on the schedule. The meeting paper were circulated, was tabled at the meeting, but not circulated to all members before the meeting. One director attended the meeting through a video conferencing, and he argued that the director should not be counted as the quorum. The director did not attend the meeting due to another engagement. And before the board meeting, Wei proposed Anna could add his alternate to attend the board meeting. Anna is not a director. Jane asserted that Anna was not permitted to attend the board meeting as an alternate, as she did not have the authority. Jane argued that Wei's proposal for asking Anna to add his alternate was invalid because the board has never approved the appointment. Okay, needless to say, when you give the answer of alternate director, please focus on this part of information. Now, let's take a look on the examiner comments, okay, including that this was the most popular question, but answer performance is not very good. First of all, students were not familiar with the requirement for holding the board meeting under the model articles or for listed company under the CG code. Students were not familiar with the formality for appointment of alternate directors. The question also asked to comment on Steve's argument, but the answer did not evaluate his argument, only provide a very descriptive answer on the procedure for convening and holding the board meetings. And some students confuse board meeting with general meeting. This means that they have no knowledge on the whole syllabus. Interestingly, if the student has a very good ideas on board meeting, he or she score high mark on that question. So very extreme. Some student has a very high mark, but some student has a very low mark. Okay, now let's take a look. Because there are some arguments that we can make use of every argument as a headline. First of all, board meeting convened by the chief executive. According to the articles, any director may call a director meeting by giving notice to the directors or by offering the consent to give notice. James is not a director, only a chief executive, so that she has no power to call a meeting. Jane may have the power to call the board meeting with the director delegate the power to Jane. How about inaccurate notice? According to article, notice of board meeting must include the proposed date and time and where this is to take place. There is no notice requirement in the AA unlike shareholder meeting. Reasonable notice must be given. With Jing properly inform each director of meeting day, time, and venue, the notice is deemed to have been properly served. How about using phone call at the meeting? The article specifies the notice of the director meeting must be given to each director, but need not be in writing. Okay, so that the meeting convened through the phone call can comply with the article. How about the day on November 2 was not on board calendar schedule? According to AA, there is no requirement that the board meeting must be held in any specific interval or predetermined day. Therefore, the board meeting is properly convened and held according to the articles. Meeting day on November 2 is in order. How about the meeting paper? According to the article, there is no requirement that the board meeting paper must be provided to each director prior to the board meeting. In this connection, the meeting paper provided to each director are in good order. How about attend the board meeting through a legal conferencing? According to the article, in determining whether the directors are participating in a meeting, it is irrelevant where a director is or how they communicate with each other. This means that will-be attendance at the meeting through a video conferencing can comply with the article, so that she can therefore be counted as a quorum of the board meeting. How about we did not attend the meeting? The article specified the quorum, for the meeting can be decided by the director, and unless otherwise, it is true. Although we is absent from the meeting, the board meeting may be properly held with 2 or more directors attended the meeting. How about the formality for the appointment of alternate directors? According to the articles, the director may appoint the alternate, any other director or any other person approved by the directors. As Anna is not a director, the appointment of Anna is subject to the board approval. Without the board approval, the appointment of Anna as way alternate is invalid. She did not have the authority to attend the board meeting. The article also specified that the appointment of the alternate by the appointer must be effected by the notice to the meeting. The notice must be agended by the appointer. The notice must identify the proposed alternate and contain a statement agended by the proposed alternate indicating the proposed alternate willingness to act as the alternate of the appointer. Therefore, we should comply with the board requirement, including give the notice to the board. The notice must be properly agended by the way, and Anna must indicate her willingness to act as the alternate director in a statement. The appointment of alternate director requires filing of Form ND2A, which should be filed to the CR within 15 days after the appointment. Anna must consent to act as alternate directors. After the alternate director is appointed, the register of directors must be updated. The article specifies that alternate director has the same right as the alternate appointer in relation to any decision by the director. The alternate director is deemed for all purposes to be a director. The alternate director may be counted as part of the quorum for the board meeting and sign a written resolution. How about another part? Assuming that the company is a listed company, what will be the difference between the answer on private company and listed company? Regarding the board meetings as well as appointment of alternate directors. So that's the reason why, apart from articles, the listed company must also apply CG code, that is Appendix C1 of the listing rule. So that let's take a look on the CG code requirements. In case of any deviation from the CG code provision, the company must give considered reason in this annual report or interim report. So that again, using the same headline, what will the difference on the answer? But the company is a listed company. According to CG code, the chairman of the board should be primarily responsible for drawing up and approving the agenda for each board meeting. He or she should take into account any matter proposed by other directors for inclusion in the agenda. The chairman may delegate this responsibility to a designated director or to the company secretary. Therefore, without any proper delegation by the chairman, Jane, as a chief executive, does not have any authority to convene a board meeting and draw up an agenda for the meeting. How about the same headline, inadequate notice? CG Group requires that the notice of board meeting should be at least 14 days, which is regular board meeting to all directors, or all other board meeting reasonable notice should be given. The company is also required to follow the requisite notice periods as set out in the article. If there is no specific notice periods in the articles, it is advised to give a 14-day notice period for good CG. How about using phone call? There is no specific provision in CG Code how the notice of board meeting should be given to the directors. For CG practice, the company should send a written notice together with a proposed agenda of the meeting to the directors at least 14 days. This ensures that all directors are given an opportunity to include matter in the agenda for the board meetings. How about November 2, which was not on schedule? CG Code specifies the board should meet regularly and the board meeting should be held at least 4 times a year as approximately quarterly interval. The company is required to hold a minimum of 4 board meetings without any requirement for a maximum number of board meetings, so that the board meeting on November 2 comply with the CG Code. How about meeting paper at the meeting? CG Code specifies the agenda and accompanying board meeting paper should be sent in full to all directors. This should be sent in a timely manner and at least 3 days before the day of board meetings. Without any agreement by the director, the meeting paper provided at the meeting deviates from the code provision, and therefore the company needs to give considered reason in this annual report or interim report. How about attend the meeting through video conferencing? CG Code specifies the board meeting will normally involve the active participation, either in person or through electronic means of communication, of a majority of directors entitled to be present. Therefore, movie attendance at the meeting through video conferencing can comply with the CG Code. How about Wei did not attend the board meeting? According to the CG Code, the board meeting involved the active participation of a majority of directors. So long as the number of directors attend the meeting meet the quorum according to the article, the board meeting is considered properly held. Okay, finally, how about another headline, appointment of an alternate director with the company is a listed company. Apart from the Part A procedure, there are some other additional procedure, okay, including the public announcement, okay, including the appointment of the alternate directors, and provide the update contact information of the newly appointed alternate directors. And now, this rule has been updated because Form B has been abolished. Okay, however, the alternate director should receive a legal opinion from the firm of solicitor in Hong Kong with regard to the director duty, listing rule, and company law. Okay, so that the director undertaking has been included at the listing rule, so that Form B has been abolished by the listing rule. The company should maintain the website, the update list of directors, identifying their role and function according to the CG Code. With the newly appointed alternate director has the interest in share of the listed company and or any of these associate corporations, he should complete Form BA and file the DI form with the stock exchange within 10 business days after the appointment under Part X3 of the SFO. Let's continue to look at 220 November's. Okay, before we look at the scenario, please take a look on the question requirements. Okay, there are 2 proposed amendments to the articles. What will be the differences between passing a resolution in a general meeting and passing a written resolution? And the role of the chairman at the general meeting, 16 marks, so that you should write around 3 pages on that answer. different intention of asking the shareholder to vote by a show of hands whether the shareholder could be able to demand a poll, and a poll could be conducted by Mark. Okay, so I expected to wait around, let's say, 1.5 pages. Okay, now let's take a look on the question requirements. Okay, and please look that the company type is a private company, and interestingly, the question highlights that the company is not a listed company. So please do not provide any answer on the listing rule. And there are two types of shareholders, ordinary and preference shareholders. Please take a look on the respective percentage. Now, to convene a board meetings, to amend the articles, to allow ordinary shareholders to receive scrip dividend, and amend the article to pay a preference shareholder in the future a larger fixed annual dividend payment, rather than two payments annually in order to help the cash flow. The chairman is keen to complete this as quickly as possible. He said that there are three shareholders. Has agreed that Vertigo does not have to wait for the applicable notice for convening a general meeting. Stewards could support this because passed by a written resolution. If the general meeting is listed, Stewart wants to chair the meeting in a way that suits him. In particular, he wants the shareholders to be voted by show hand. However, he said that Alok and Jane may insist on a vote by way of a poll. Stewart thinks that this is too time consuming and will not make any difference to the voting result. He asks you when a poll may be demanded and expand the procedures. Okay, so that let's take a look. There are many background information from the case. Look is the comment from the examiner. Okay, part A asks you about amendment of articles and compare the passing resolution in a meeting and passing a written resolution. Although some students they are familiar with passing resolution, they did not make full reference to the scenario. In particular, the company is a private company. However, there are some candidates only provide the answer for a listed company, and also provide answer on convening the AGM or EGM. There is no reference to the specific case. Part B also asks about whether the shareholder could be able to demand a poll. However, not many answers are relevant to the case properly. Only few students were able to define the major differences between a show of hand and a poll vote. Okay, now let's take a look on the subjected answer and using the headline, something like about the holding a general meeting to illustrate the differences between passing a resolution at the meeting and passing a written resolution. Okay, first of all, for holding a general meeting, because there are more than one class of share, and each proposal needs to be considered separately by the relevant shareholder. For the amendment of the articles for the first item, this should be considered and a special resolution must be passed by a ordinary shareholder. For the second amendment of articles, the separate class meeting for preference shareholder is required whenever their rights are to be valued. Not only preference shareholders, ordinary shareholder approval is required because just larger fixed annual dividend payment could affect the dividend payment to the ordinary shareholder. The length of the notice must conform with the articles. So that for AGM, at least 21-day notice. For any other meeting, at least 14-day notice. The notice period is 14 clear day notice. The day which the notice is served and the day when the meeting is to be held are excluded. The CEO allowed the notice period for the general meeting to be shortened to any closer alternate day. Short notice is valid for the AGM only when approved by all the members. For other general meetings, this must be approved by the majority representing at least 95% of the total voting right. Since Frankie and Coda hold 85%, then cannot fulfill 95% requirements. They need at least one further holder, that is at least 10% to agree for the consent of short notice. In regarding the preference shareholders, Gold has the holding of 95%, so that is sufficient for a valid consent to short notice. Okay, so that everything focus on meeting. How about written resolution? Only member may pass a written resolution. Okay, then under the CEO, before passing the written resolution, the company must circulate a proposed written resolution to all members who are entitled to vote, okay, which is not more than 5% of the total voting power. The member who propose a written resolution may request the company to circulate a statement of not more than 1,000 words on the subject matter. The company is not bound to circulate the statement when the court is satisfied that the way is being appealed or being used to secure needs their placidity in a definitive matter. The circulation can be in hard copy or in electronic form or available in the company website. Member may certify their agreement and sign back the resolution to the company in hard copy or in e-copy. The period to agree the proposed written resolution is 28 days or any other days agreed by articles. The written resolution is passed when all members have certified their agreements. When the resolution is passed, the company must send a notice to every member and the auditors within 15 days. And the final part illustrates the role of chairmen at the joint meetings. The chairman must make sure that the meeting should be properly held and fairly conducted and allow opinion to be expressed and sense of meeting is properly asserted. The article gives the chairman specific powers on the conduct of the meetings, and the chairman has to need to assert member rights in respect of demanding a poll by ways of poll. In case of any disorders happen during meetings, the chairman may adjourn the meetings. Members may be ejected if their behavior is so disturbing during the meetings. And every motion should be made to allow members to weigh matters in an appropriate manner. Okay, how about the second part? Okay, again, you can see the headline, okay, like that. To vote by show of hand whether the shareholder could be able to demand a poll and how a poll could be conducted. For a private company, there are two methods. That is show of hand or a poll. One share, one vote. For demand a poll, please look at CO and articles. The poll may be relatively demanded by at least 5 members having the right to vote of the meeting, or the member representing at least 5% of the total voting right, and also chairman. When before or declaration of the result of show of hand at the joint meetings, where the chairman know that shareholders' result will be different from that on a poll, the chairman must demand a poll. Since Alex holds 4%, he cannot demand a poll vote, and he needs support from other shareholders. James holds 10%, therefore James could demand the joint meeting to vote for a poll vote. For a show of hand, each member in attendance has 1 vote. On a poll vote, the number of votes for each member is calculated by reference to the number of shares held. Given the difference in size holding, the vote on show of hand may give a very different voting outcome when compared with the poll vote. While conducting a poll vote does usually require additional administration, there are only 5 shareholders. A vote on this basis can be completed very quickly. For the demand of poll to be valid, this must validly call before or immediately on the declaration of the chairman of the result of the vote on a show of hand. Given there are only 5 shareholders, the poll can be taken immediately. The ComSec should prepare ballot paper in advance. The ComSec should expand the process to complete and return the ballot point. The completed ballot paper should be handled by the company secretary to count the vote. Then the chairman will then formally confirm and announce the poll result.
Okay, now let's continue to look at Section D, okay, of a past exam paper regarding share capital, and debt capital. Okay, let's take a look on 223 November. Okay, before we look at the scenario, let's take a look on the question requirements. Okay, the major terms and provision that must be included in the scheme document according to Chapter 17 of the listing rule. That is 16 marks. Okay, so that you are expected to provide 3 pages on that answers. Line mark for to repaging law share certificate. That is line mark. So you are expected to write around 1.5 pages on that. Okay, now let's take a look on the background information. Let to say the company must be a Hong Kong listed company because of the listing rule. And the company is a Hong Kong company. Okay, regarding the second paragraph, regarding the company intended to adopt a share option scheme as an incentive scheme to recognize a contribution by the employee for more than 10 years, as well as to demonstrate outstanding performance. The share option scheme provides eligible employee with the option to purchase the shares and enable them to participate in the benefit from the company group. The company has never adopted a share scheme, then please discuss the necessary formality for the adoption of share option scheme, including drafting the scheme document. And Jing hold 10,000 shares. The market value is 210,000 Hong Kong dollars. Xu wants to transfer his 10,000 shares to the charities, but he cannot find the share certificate. Now, let's take a look on the exam comments. Regarding share option scheme, which was the least popular question, and student performance was very, very disappointing, just because the student may not have sufficient knowledge on Chapter 17 of the listing rule, so that they are unable to describe terms of the share scheme accurately. For Part B, only a few number of candidates demonstrate statutory knowledge of the procedure for repayment of lost share certificates. Okay, so that a number of students only adjust one part of the question and fail to answer another part, so that they will fail in the examination because they have not sufficiently revised the whole syllabus. Okay, now let's take a look on what is the share scheme under the listing rule. The share scheme document must include the following terms and provisions, including the purpose of the scheme, the participant of the scheme, and the basic for determine the eligibility for the participant. The total number of shares that can be issued in effect of option to be granted under the scheme. That is the scheme mandate limit, which must not be more than 10% of the issued share. The maximum entitlement of each participant, that is, must be less than 1% in the 12-month period. The period which the action may be exercised by the grantee, that is, must not be more than 10 years. The vesting periods of options shall not be less than 12 months. The description, that is qualitative and quantitative, of the performance target attached to the option to be granted under the scheme with no negative statement to that effect. The amount payable on application or acceptance of the options, and the periods which the payment or call must be made, or within which loan for this purpose must be repaid. The basic for determining the exercise of share options, or the purchase part of the share awards, which must be at least the highest of the closing part of the shares, okay, on the day of grant, and the average closing part of the shares for the 5 business days immediately preceding the day of grant. Anyways attaching to the option, for example, voting, dividend, or transfer, including arising from liquidation. The life of the scheme which must not be more than 10 years. The circumstance which the option may automatically lapse, for example, with the employee resign. A provision for adjustment of the exercise price of purchase price and or the number of shares subject to the option granted under the scheme in case of capitalization issue, right issue, subdivision, or consolidation of share or reduction of capital. A provision for the cancellation of the option granted, transferability of option or award. No option may be transferred or assigned. When the company has established a chargeback mechanism to recover or withhold the remuneration to any participants, in case of any serious misconduct, a description of the chargeback mechanism or no negative statement to that effect. Okay, so you must be familiar with all the terms which must be included at the share scheme. Now look at the Part B question. The procedure to replace a lost share certificate, again, depends on the value covered on the share certificate. Since the market value of shares in lost share certificate is more than $200,000, the procedure includes, according to the CO, Jing should apply to the company or share registrar for the repayment share certificate. Then, Form SS1, together with the statutory declaration, including that the original certificate has been lost, when the original certificate was last in Jing possession, and how Jing ceased to have possession of this, whether Jing has executed any transfer in respect of the shares. No other person is entitled to have their name entered in the register of member. Many other matters to water the ground on application. After receive Form NSC1, check to ensure no stop notice or court order has been received. A stop notice is a court order obtained by judgment creditor restricting the transfer of specified shares of the judgment debtor. Then the company can publish Form NSV on the company website for 3 months and forward the stock exchange a copy of the form, which will be exhibited in the concept page or posted on the website of the stock exchange for the period of 3 months. Then publish the form in the Gazette within 1 month after publication of Form NSV in website. With no claim and loss within the 3-month period, the company should prepare a new share certificate and submit to them to the board approval. Board resolution should be passed to approve the cancellation of the lost share certificate and issue a new share certificate. Then record the cancellation of the original share certificate and issue a new share certificate in the register of members. Then notify Jing the new share certificate is available for collection. Within 14 days after the issue of new share certificate, then the company public Form NS4 on the company website for a period of at least 7 years and deliver a copy of this form to the stock exchange. Okay, so that student must be familiar with all the formality for lost shares.
Log 2023 June. Okay, looking at the question requirements, 12 mark and 13 mark respectively. So that's 2 pages for each part of the question. Okay, please provide a means that the company can increase its shareholdings in Goddessence. And very straightforward, some way how to increase the shareholding for the shareholders. Whether the company can refuse hybrid requests in relation to inspection and obtaining the pinned copy of the statutory record. Okay, now let's take a look on the scenario. First of all, what is the type of company? Okay, the company is a private limited company incorporated in Hong Kong. And the company has a shareholder, Scorison, own 10% of the issued shares. They are not the listed company, so please do not mention any listing rule. Okay, and now the hybrid want to increase these shareholders, including that first from 10% to 20%, and then from 20% to 40%, and then finally to 60%. What are the means in order that hybrid can increase his respective shareholders? Jing informed that hybrid intend to make inspection and obtain pinned copy of the following statutory record, including register of directors, register of member, and all resolution of member and minute of all proceeding of the general meetings. And some of the record have been lost, whether the company can refuse hybrid requests. Okay, so that the first part focus on A, and then this part focus on part B. Okay, this means that the question is quite straightforward regarding how to increase the shareholdings, how to provide the right to make inspection and require copy of the statutory records. Part A is very good. Overall, there are 2 ways to increase the shareholding. One is allotment of shares and other one is transfer of shares. Unfortunately, candidates should read the fact carefully from the scenario. Remember, the company is a private company, not a listed company. And interestingly, I don't know why, students mentioned about mandatory general office, SFO, which are totally unrelated to that question. Okay, so that they failed in the examination. Okay, I don't know why. The company is not a listed company and private company only. Why apply SFO or GL offer? Okay, and part B, again, student performance is not good. Students have no knowledge on statutary of the shareholder to make inspection and require copy of the statutory record. Okay, now let's take a look on the two means to increase the shareholdings. Okay, one is subscription of new shares by way of allotment of shares, and other is to acquire the company shares from the existing shareholders by transfer of shares. Okay, first of all, what is allotment of shares? Allotment of shares is the creation and issuing of new shares by the company, which can be issued to new or existing shareholders. Articles give the director the power to allot new shares. However, with the new shares are not allotted to the person member on a pro rata basis, the shareholding of the person member will be diluted. Under the CO, provided that the new shares are offered to the person shareholder on a pro rata basis, for example, right issue, the director must not allot share or grant right to subscribe for share, for example, warrant or option, or convert security into share, for example, convertible debenture, without the higher approval of the shareholders. The right gives the person shareholders the right to take up new shares before the new shares are offered to other shareholders. Once shareholder approval has been obtained, director may exercise the power to allot shares. Form NSC 1 should be filed with CR within 1 month after the allotment date. With the share allotted for consideration other in cash, certified copy of the related contract must be filed together with the Form NSC 1. With the number of shares allotted more than the maximum number of shares, the company may stay as stated in the capital cost of the articles. The company needs to altern the capital cost by ordinary resolution of the members. With the company intend to increase its shareholdings by subscription of company new shares by allotment of shares, the company must obtain prior shareholder approval, and the number of shares to be issued must be within the maximum limit as stated in the articles. How about the second means? That is transfer of shares. Okay, please highlight all the procedure for transfer of shares. Shares are personal properties, and every shareholder has the right to transfer shares, unless the article provided otherwise. Okay, so that Section 11 of the CO provides private company must include these articles, the restriction on transfer of shares. The restriction of transfer is that any member of the company must first offer to the shares to the existing member, and none or only a proportion is taken up. The remaining number of shares could be offered to non-member. The buyer and the seller are required to execute the duly stamped interest transfer together with the board and solo, and also board approval is required. The interest transfer board and solo must be presented to the stamp office of the IRD, together with the latest audit account for certification of the stamp duty. Within 2 months after the share transfer is lost, the company must register the register of transfer or send the transferee or transferor the notice of refusal. The company must send to the person who makes the request a statement of the reason of refusal within 28 days from the receipt of the request. Once the director approval has been obtained, the company must then record the new ownership of share in the register of member and issue a new share certificate to the transferee and cancel the old share certificate. If the company intends to increase this shareholding in company by execution of the company share from this existing shareholder by share transfer, then Highbury must execute the share transfer document, pay the adjudication fee and stamp duty, and obtain director approval. How about the second part? The rights of inspection and request for the copy of the stat record. Okay, according to the CO, all the stat record must be kept at the register office or any other place other than the register office. There are mandatory register, including register of member, SC register, register of directors, register of company secretary, and register of charges. If the registrar are not kept at the register office, then Form NR2 must be filed with the CR within 15 days for any location of this register because of the strength of the location of keeping secretarial record. Now, first of all, looking at the register of member. According to CO, if the company is a private company, this register of director must include the following, including the natural person, the person and the person forename and surname, former forename or surname, the correspondent address, okay, just because of new inspection regime, and also parcel ID number or parcel ID passport, including the issuing country held by the directors because of the new inspection regime. With the director is a body corporate, the corporate name and the address or the register office address. The member can make the request in a prescribed manner and without charges to make inspection on the register of directors. The person is entitled on request or payment of the prescribed fee to be provided with a copy of the register of director or of any part of this. The company may withhold the following particulars by providing the correspondent address and parcel ID number or parcel passport number only. The register of company keeps the index of director of private company. In the case where certain information of register of director has been lost, the company may obtain director particular from the index of director kept by the CR. However, the user register address and full ID number and passport number must be protected and cannot be opened for inspection. Therefore, the shareholder has the right to make inspection and request a cleaner copy of the register of director. However, the director particular, for example, register address, full ID number, and passport number do not have to be disclosed to the shareholders. How about register of members? The register of member must enter the name and address of this member, the day which the person is become a member, and the day which the person ceased to be a member. In case of share capital, the register of members should include the share held by each member, the amount paid or agreed to be considered as paid on the share on each member. The company must enter into the register of member within 2 months after the company has received the notice of the said particular. In case the member has ceased to be a member, all entry related to that person may be destroyed after the end of the period of 10 years from the day of cessation to be a member. A member of the company is entitled, on request made in the prescribed manner and without charges, to inspect the register of member. The person is entitled on request and payment on a prescribed fee to be provided with a copy of the register of member. Therefore, the shareholder has the right to inspect and request a pin copy of the register of members, and except for those who has been destroyed because more than 10 years has passed since they ceased to be a member. How about the resolution of member and minute of all proceeding of general meeting? The company must keep record, including copy of all resolution of member passed other than at general meeting, minute of all proceeding of general meeting for at least 10 years. The member of the company is entitled on request made and in the prescribed manner and without charges to inspect all the resolution of member and minute of all proceeding at the general meeting. The member is entitled on request and on payment of a prescribed fee to be provided with a copies of all of the records. Therefore, the shareholder has the right to inspect and request printed copy of the resolution of member and minute of all proceeding of the general member, except that for those shareholder meeting minute which have been destroyed because of more than 10 years since the resolution has been passed since the date of that at 2022 November. Okay, the question is quite straightforward just because when you see everything highlight, only transfer of shares and lot more shares. And interestingly, even though they are the two means to increase the shareholding of shareholders, however, for transfer of shares, the mark is 17 mark. For a lot of shares, the mark is only 8 mark. In other words, you are expected to write around 3 pages for transfer of share only, and write around 1 to 1.5 pages for allotment of shares. Okay, so the question is very, very straightforward. How about the type of company? Okay, again, Hong Kong company. Okay, and the company adopt model article. That's very straightforward. At the board meetings, explain to Richard, which approached the shareholders of the company expected an interest in purchasing the shares. Some of shareholders has told Lisa that the shares should not be sold to Richard, and any transfer of shares shall be split pro rata between all existing shareholders. Richard claimed that he has reached agreement with 2 of them to buy the shares and that he has received a letter from both these shareholders, which Richard claimed is sufficient authority and documentation for the share transfer to proceed. However, Lisa said that she could prefer that 2 other shareholders remain with the company and recommend the board does not accept any request to transfer the shares. And she assumed that the board can do this without need to provide Richard with the explanation. Now look at another potential investor, Amanda. She wishes to make investment in the company, and based on allotment of shares, there are 2 types of consideration. One is $10,000 in cash and a business premises worth $1 million, which the company needs in order to develop this operation. Although the premises has not been valued, Lisa thinks that this is a fair price. Okay, Lisa recommends the board proceed immediately with the amended offer, but is not sure whether this is permitted. Okay, so you can see student performance is quite straightforward. Okay, in particular, transfer of shares is one of the hit topic in the examination. So that student performance for transfer of shares is very good. However, how about allotment of shares? Unfortunately, students may not have sufficient knowledge on allotment of shares under CO nor under the model articles. Okay, for 17 mark, okay, how about restriction on transfer of shares? How to transfer the shares to Richard? Okay, model articles specify that the member right to transfer the share is restricted, and the director may, in their discretion, refuse to register the transfer of shares. Also, Section 11 of the CO provide that all private companies must contain in their articles restriction on share transfer, prohibition any invitation to the public to subscribe share, and the number of members should not be more than 50. The preemption clause provided that any member who intended to sell their shares must first offer them to the person members, including that he should first serve a written notice of the intended sale on the director of the company. The notice should specify the number of shares you intend to sell and the sale price. The notice usually operates to appoint the directors as its agent for the sale. The director must then notify all other members of the company the intended sale and to invite them to offer to buy any number of shares during a prescribed time period. In the event that instead of offer, the shares are allotted to the offerer in proportion to their shareholding. With any of the shares remain unwanted, or the person member waive their right, the share can be purchased by the non-member. Therefore, without evidence showing that the said right has been waived by the existing shareholders, the board should not pass a resolution to approve the share transfer to Richard. Okay, how about director refusal to approve the share transfer? The notice of refusal must be served on both the transferor and transferee within 2 months. The proposed transferor or transferee may then request a statement of the reason for the refusal. If the refusal is made, the company must within 28 days after receiving the request send to the person who made the request a statement of the reason or register the transfer. If the person who made the request is not satisfied with the reason, he or she may apply to the court for the court orders. If the court is satisfied that application is well-founded, the court may order the company to register the transfer. Then how about the procedure to move forward with the share transfer? Okay, the company must not register the share transfer unless the proper interest transfer has been delivered to the company. The share may be transferred by means of the interest transfer, which should be executed by the transferor and transferee. Not only the interest transfer, the form of transfer also includes bought and sold loan, and the transferor must present the relevant share certificate. Once the board has passed the resolution to approve the share transfer, then the following document must be presented to the stamp office (IRD) for adjudication of the stamp duty, which include interest transfer, bought and sold loan, audit financial statement, okay, and also this consolidated account with the company owned the subsidiary. Articles, if there is any agreements for sales and purchase of the share. A statement of whether the company and this subsidiary has acquired any landed properties, so that Form IRXD 102 must be submitted to the IRD for the assessment of the stamp duty. Return of allotment, Form SSC1 for the increase of share capital which has not been reflected in the annual return. If the interest transfer is executed in Hong Kong, this must be submitted to the stamp office for adjudication on the day of execution. A fee of $5 is payable. If the form is executed outside Hong Kong, this needs to be presented within 30 days after execution. The bought and sold loan should be presented to the stamp office for adjudication of any royalty duty payable within 2 days. And please note that the stamp duty now is 0.2%. That is 0.1% by transferor and 0.1% by transferee. And the ad valorem duty should be shared equally by the transferor and transferee. How about the penalty for late stamping? Okay, in case of no later than 1 month, 2 times. Later than 1 month, but no later than 2 months, 4 times. More than 2 months, that is 10 times. Update the register of transfer and register of member and SCR register with necessary. The effective date of the share transfer is the date of the registration of the standard transfer document, or the date of the board resolution approving the share transfer, whichever is the later. Cancel the old share cert and issue new share cert. The new share cert must be issued within 2 months after the date of the lodgement of the transfer document. Therefore, Richard cannot request the board proceed with the share transfer with he had not yet submit any duly executed interest transfer or bought and sold loan to the company, and the board has never approved any share transfer in this regard. How about the second part? Allotment of shares. Okay, more article gives the director the power to allot new shares. If the new shares are not allotted to the person member on a pro rata basis, the holding of the person member will be diluted. The article specifies the director must not exercise any powers to allot shares without prior approval of the company. Therefore, unless the new shares are offered to the person shareholder on a pro rata basis, the director must not allot shares, grant right to subscribe for shares, for example, option, or to convert security into shares without the prior approval of the shareholders. The person shareholder has the right to take up new shares on a pro rata basis before new shares are offered to other investors. Therefore, if the said right has not been waived by the existing shareholders, the board should not pass the resolution to approve the allotment of shares. Shareholder approval must be given to the shareholders for the exercise of power, in general mandate or specific mandate, and may be unconditional or subject to a condition, for example, a maximum of shares to be issued, or a specific period. When a specific mandate has been obtained, and then arrange for letter of application for shares to be issued by the proposed allotee, and ensure that payment for the share to be issued or an undertaken to pay, convene and hold a board meeting to note the receipt of the letter of application of shares, approve the allotment of shares, issue new share certificate, and affix the seal at the share strip. The consideration can be in cash or in kind. For non-cash consideration, particulars must be set out in the Form NC1, and the form should be filed with the CR within 1 month. And certified copy of the related contract and agreement needs to be filed for allotment of shares, which is non-cash consideration. Finally, update the register of member issue the new share certificate within 2 months after the allotment of.
Okay, now let's continue to look at 221 June. Okay, that is the final question for today's exam technical workshop. Okay, for this question, I also highlight the keywords from the question. Okay, including the obligation of the directors and requirements in respect of paying dividend. Any action which the director may need to take part to approving any dividend payment. And also the rights of the shareholders to receive dividend. Okay, 11 marks, so that you are expected to write around 2.5 pages. Regarding the director verbal resignation, and also removal of Susan and Sandy are valid. Okay, so that you can see there are many headlines for director resignation and director removal. And assess whether you should file the form with the CR in respect of the director resignation and removal of director. That is 14 marks. Okay, so that you are expected to write around 2.5 pages. Okay, now let's take a look on the background information of the case. Again, the type of company is a Hong Kong private company, not a listed company again. And there are 3 classes of shares: ordinary, preference, and accredited preference shares. The company has a profitable history, and the shareholder likes the level of dividend that has been paid. However, there are some struggling, including the threat of continuing to make the company a success, which has impact the board, and there has been frequent disagreement at the board meeting, including the approach to pay out the dividend. Some of the directors insisted that all shareholders are entitled to dividend every year, and are keen to maintain historical dividend payment. Directors Susan and Sandy believe that the company must reduce or stop paying dividend for the next 2 years. Janet is a chairman. After reviewing the audit financial statement, the company is able to pay dividend. The CFO agreed with the chairman, and he advised the board to maintain the dividend payout ratio for each class of shareholders. And Ruby, a director, tendered her resignation verbally. Okay, Janet dispersed to you so that other director cannot hear. An instruction that she thinks will put an end to the arguments. She tells you to file the form with the CR at the end of the meeting of her resignation, and to remove Susan and Dandy without notifying them, and then remove them as our director. Okay, so that you can see the final paragraph related to part B of the question requirements. Okay, the performance of this question was very, very poor. Part A asks about the obligation of directors and the requirement to pay dividend, but unfortunately, the answer was very poor. Remember, dividends are only paid out of the accumulated realized profit less this accrued realized loss. And Part A also asks about the rights of shareholder holding ordinary preference and accumulated preference shares. Some candidates fail to point out the difference between them. And everything is only a fundamental concept. Part B asks about the candidate about the process of resignation, removal of directors. This part was very answered very well. Most candidates has a very good answers on director resignation, removal of directors, and handling the filing procedure. Okay, now let's take a look on how to pay dividend. According to the articles, the company may only pay a dividend out of accumulated realized profit less this accumulated loss. Realized means in the form of cash or other form convertible to cash. With company pay dividend, they may be cash, fully pay up share, for example, with dividend, fully pay up share, that is bonus share, bonus warrant, or pay up securities of other company, that is distribution in BC. A final dividend must be justified by the latest financial statement laid before the AGM. The final dividend can only be paid with the recommendation from the directors and has to be approved by the shareholders at the AGM by ordinary resolution. However, the interim dividend payment may be justified by interim financial result, and interim dividend may be paid with the approval of the board of directors. The director should make sure that the payment is justified by the company interim financial result. When the board resolution to pay an interim dividend has been approved, the director may make the payment. No shareholder approval is listed. If the company make a distribution to this member, violating the CO, the distribution is made in cash. The member is liable to repay the dividend to the company. If the distribution is made in non-cash, the member is liable to repay the company a sum equal to the value of the distribution. Therefore, the director must make a careful analysis of whether the financial position is sufficient to pay the dividend. How about the rights of shareholder to receive dividend? First of all, ordinary shareholder usually hold voting share. They have the right to receive dividend without any upper limit. They will rank behind other class of shareholders that have a preferred or fixed dividend entitlement, for example, preference shares. When the company become bankruptcy, preference shareholders are entitled to be paid from the company asset before ordinary shareholders. Ordinary shares generally do not have a fixed dividend. Okay, now look at Part B. Okay, regarding resignation of directors. The director may resign at any time according to the procedure and requirement as set out according to the company articles, including that the director resigner should serve a notice of resignation and sign a letter of resignation and send it to the company. And after receipt of the notice of resignation tendered by the resigned director, the board of directors should consider, is there any disagreement between the directors? If the director resignation is accepted, then the board should approve the resignation at the board meeting or board resolution. Update the register of director. File the Form ND2A with the CR within 15 days after the resignation. The CO specified that with the notice of resignation of the director is required under the articles, then the resignation does not take effect unless the director gives notice in writing of the resignation, including the receipt requirement, by leaving it at the register office or sending it to the company in hard copy or in e-form. The resigned director does not tender her resignation letter, only provide the oral resign. And the board does not pass any resolution to approve her resignation. The resignation does not effect. Therefore, the company should not file Form ND2A with the CR. How about the second part, removal of directors? Let's take a look on CO. The company may by ordinary resolution remove the director after the end of the director terms of office. Backstop notice is required to remove the directors or to appoint somebody in replacement. A backstop notice means the notice of the proposed resolution must be given by the member to the company at least 28 days before the general meeting. On receipt of the backstop notice, the company must send a notice to the director concerned, who is entitled to be heard or to make representation. The representation are required to be circulated beforehand or must be read out at the meeting. On a resolution to remove the director, no share may, on a poll, carry more vote than this could carry in relation to the generality of the matter to be voted at the general meeting. A written resolution cannot be used to remove the directors. Okay, so that this must be passed at the general meeting by ordinary resolution. At the general meeting, after passing the ordinary resolution, the company should file the Form ND2A with the company registry within 15 days after passing the ordinary resolution. The register of director must be updated. In conclusion, only shareholder can serve a backstop notice to remove the directors. As the company does not receive any backstop notice from the shareholders, and the board does not convene any general meeting to approve any ordinary resolution to remove the directors. Therefore, the director removal does not have legal effect. Therefore, the company should not file the Form ND2A with the CR. Okay, now we have go through all the past exam papers for Section C and Section D under the syllabus, and I hope that after we go through all the question requirement and exam report, you should know what are the major focus for Section C and Section D. And more importantly, please also look at why student performance in the past may be good or poor. Please do not repeat the mistake. Okay, so that reading the past exam paper is very important for you to know more about the strategy, how to present the answer. Okay, now today we can finish our Part 3 exam technique workshop. Okay, then let's go to Part 4. Okay, of the exam technique workshop, which we will focus on Section E of the syllabus. Okay, thank you for attending today's exam technique workshop. Okay, see you next Part 4. Bye-bye.